SJC-13043, Commonwealth versus Peter Ronchi.
Okay, Attorney Fishman, good morning.
Good morning. May it please the court. Before I begin, I'd like to note the presence of defendant's children, Stephen and Lizette, in the courtroom. May it please the court, my name is Neil Fishman. I'm here for the defendant, Peter Ronchi. This is an appeal, from 2 first-degree murder convictions. One is based on extremely cruel and atrocious killing regarding that is and deliberately premeditated killing regarding the his pregnant girlfriend who was 9 months pregnant at the time. The other is regarding the fetus, and that is a deliberately premeditated first-degree murder conviction. I will begin with some of the handle things a bit differently from I handled them in the brief. I'll begin with some of the new trial issues, of which there are many. In looking back, it seemed to me that some of the, they're all quite strong in my view, but some of the stronger ones were actually unpreserved. For example, during closing argument, the Commonwealth told the jury that mere words could not satisfy a manslaughter conviction. That was an incorrect statement of law, and indeed, that was the whole ball game. That was defendant's defense, of course, which was that he received word orally of the decedent's infidelity and the fact that of his lack of paternity. The Commonwealth actually went even further in their closing argument and actually tied that proposition of law, which is false, to the facts of the case. The Commonwealth said,
did the judge draw the distinction between mere words and mere words that inform in the jury instructions? In
the jury instructions, Your Honor, the court handled the topic appropriately. They were consistent with the...
Did the judge instruct the jury that you get the law from me, not the lawyers?
There was the standard instructions, Your Honor. Nevertheless,
Didn't the prosecutor actually call upon the jury to listen to what the judge is saying right before talking about the mere words?
I don't recall if that's in the prosecutor's closing.
Yeah, the prosecutor says, I suggest to you when you listen to the judge's instructions. That's the preface to the mere words.
Yeah, yes, Your Honor. Okay. I would still say, Your Honor, that that false statement of law, particularly when the prosecutor tied it directly to the facts, was a very significant error, and it created a substantial risk of miscarriage of justice, particularly when we tie it to some of the other errors. And I will go...
Don't we tell prosecutors that you can't just argue, you can't just state the law, it has to be tied to the facts, so that including the evidence that came in would be proper, I would think.
Well, that's why this error is doubly harmful, because not only was it a misstatement of law, but the prosecutor directly tied it to the facts. I would like to get that across to the court with the exact quote. So the prosecutor told the jury, when Ms. Galperina says to Mr. Ronchi, "It's not your baby," the Commonwealth will say to you, mere words are not enough. This is not so.
And then goes on to say the judge will instruct you that it's a reasonable person standard.
Yes, Your Honor. Yes, Your Honor. And again, I would submit that this error, when you take it into the totality of circumstances alongside the other errors, merits a new trial. Another big error, in my view, again, it was not objected to, and again, it comes from the prosecutor's closing argument and from I would encourage this court to look at it in its 33E review at the prosecutor's closing argument and the way the prosecutor handled the cross-examination of the defendant and the defendant's brother is sort of what I would characterize as a character assassination. The prosecutor painted the defendant as a narcissistic jerk. The prosecutor made hay out of the fact that the defendant was independently wealthy, that he visited Galperina at night, presumably when she was more available for sex, that he was friendly with another woman. There was a hint, a wink in that. That he was having a friendship with that woman while Galperina was pregnant, and that he was generous with his ex-wife and comparatively less generous with Galperina. I don't see any, I don't think this evidence was brought in good faith, even if there was some sort of distant good faith in showing motive. I would submit that this was, that the evidence, such evidence was, the probative value substantially, very substantially outweighed for its unfair prejudice to defendant. It basically, it was a character assassination, as I said. Moving on to some of the preserved errors, what the party saw this issue as the most important one in the case, and I certainly agree it was very important, is the exclusion of the testimony of a prior boyfriend who Galperina had told, no dispute here, had told, oh, the baby's not yours. Now he said in his voir dire testimony, well, she was joking. But I would argue to this court that this testimony was crucial. The fact that she may or may not have been joking went to the weight of the evidence. This was, by the way, this witness who testified voir dire, he was clearly sympathetic to Galperina, obviously having had a relationship with her.
Isn't this a judgment call by the judge as far as whether or not this pattern evidence comes in?
Well, Your Honor, I would say yes and no. So obviously, it's there's of course that Your Honor is well aware. The garden variety rule is we don't allow prior bad act evidence.
Right, and the only exception to that is adjutant.
Yes, well, actually, I was going to get there, Your Honor. Would you like me to address that now? I do argue for an extension of adjutant.
Right, I think that's where you were going anyway.
Yeah,
Because to get this bad act evidence by a victim, we'd have to extend adjutant.
Yes, so, and I don't think it's much of an extension, actually, Your Honor. So, as Your Honor knows, that when you have, you can prove mitigating circumstances. When there are two people in the room, and one is a defendant and one is a decedent, no, we don't have any percipient witness to the crime. We can, under adjutant, you can establish mitigating circumstances by proving that the decedent had a reputation for violence. Here, the defense was precluded from showing mitigating circumstances by showing that the decedent had told previous lovers that that the baby wasn't theirs.
Just one.
Just one, Your Honor, but given that this was the whole...
Is that an act of violence?
No, Your Honor, it is not, of course not.
So isn't this a slippery slope, what you're arguing? Really, we're just going to allow in all sorts of prior bad act evidence not tethered to any issue as to who was the first aggressor, just anything, including one other time the victim has done anything.
The jury, of course, could weigh the evidence and its credibility, but I would submit in this case where the whole ball game, again, was whether the jury believed what the defendant was telling the jury, that she said this to me and I snapped.
And so women's the language of the mother of the baby, the language was enough to provoke him?
Your Honor, under the law now and at the time of trial, yes, the language is enough to provoke him, but there was much more, right? The defendant here was suffered from very serious mental health issues. He was under enormous stress. And if Your Honor rereads his testimony, there's the argument, the build-up to the point where he snaps is quite a thing. I would like to, before I lose track, go through some of the other new trial issues, which is, again, another very big issue in the case. The defendant was trying to establish that he snapped, that this was more akin to manslaughter than murder through a mental health expert. The mental health expert, Dr. Dieters, testified that the defendant had some very serious mental health issues, which directly impacted what happened at the moment of the homicide and leading up to the homicide. But his testimony is, and I encourage the court to go through it in his 33E review, is torture. It is.
Did the judge follow Commonwealth versus Hamey?
If that's the law on how to handle this area.
DYS versus juvenile and Commonwealth versus Hamey.
Thank you.
Did the judge follow those rules?
Yes and no.
And we said recently in Penadosi that that's good law.
Yes, Your Honor.
Okay. So do you want us to change the law?
Well, let me say two things about it, Your Honor. First of all, if you look at Dr. Dieter's testimony, and I encourage you, this is a bit mixed, 33E with a direct appellate argument. But what I would encourage you,
if you could do the appellate argument first,
yes,
to
of
tell
course,
me whether or not the trial judge followed the law, then you can get into 33E.
From the defendant's view, Dr. Dieter's testimony was over-policed. The only thing he was allowed to testify to was anything he directly observed. Otherwise, it was all went through this crazy formality, which is very difficult for even an attorney to follow, for a jury to follow.
But Hamey requires, right?
I don't know if Hamey requires that. It can be only what the mental health expert observed.
What's been admitted into evidence.
Right. And what I'm saying, Your Honor, is I believe, particularly if you took a close look at his testimony, which goes on for a good 100 pages or more, is you'll see that it wasn't, the stuff that was excluded wasn't only, the stuff he was only permitted to testify to stuff.
And that's a good for the goose, good for the gander rule, because it applies to Commonwealth experts as well, right? All experts.
It does, Your Honor, it does. I would be remiss if I didn't press here for the court to loosen the reins there for the reasons that I described in the brief. I believe, again, it is.
You want us to adopt the federal rule?
I do. I think the federal rule.
703. That's
right, Your Honor. Without getting into the weeds on that, I think I make the argument in the brief that it's just too difficult for a jury to hear the nuts and bolts of what the expert is saying through the artifice of the hypotheticals. I would.
Can you just articulate for me what was excluded? I understand that you're complaining about the hypotheticals and how that needed to be presented under the current law, but what was omitted from the bases of the expert's testimony?
I believe anything that he learned.
But what was that? I understand the theory, but what was
the brother was a very important person. Whatever the brother told him, I believe he interviewed the ex-wife.
Didn't they testify?
They did, Your Honor, but of course we don't know from their testimony if it was exactly what they had told the mental health expert. Again, what was difficult about this area as a practitioner was there was so much. This is 100 or so pages of testimony, and I was wrestling with other issues as well. moving, again, another very big issue is the dismissal of the juror. Now, the discharge of the juror. I have to submit at the outset that the defendant consented to this, so review would be for substantial risk of miscarriage of justice.
And there was a colloquy too, right?
There is a colloquy, although I argue in my papers
Defense
that
attorney agrees and wants it, and the judge does a colloquy with the defendant.
I don't recall if there's a colloquy with the defendant, but that does ring a bell. I think that is correct, Your Honor. I would say, having said all that, still, the way this discharge happened was not in accordance with Connor, and it mattered. And it created a substantial risk of miscarriage of justice because this juror, by all accounts, was, she's not someone you would invite over for tea. She's a difficult person and who held a dissenting view of the case. This is exactly what Connor is about. You can't discharge difficult people who have dissenting views of the case. That's a way our system is built. A difficult person with a dissenting view of the case needs to stay on the jury, needs to be heard. In fact, if that results in a miscarriage, in a mistrial, so be it. That's the.
So the trial judge should have said to the defense attorney, "You're wrong. This juror is staying. This juror is staying."
No, Your Honor. I have to acknowledge that
No, he would have a different problem if the trial judge said to the defendant, "You're wrong. Your objection's overruled. The juror's staying," and they was convicted, right? What are we supposed to tell the trial judges?
Your Honor, I don't have an intelligent response to that. But what I would say is that this was the type of, what happened here was in directly against Connor, where, the juror was supposed to be asked she could only be discharged if she had a problem personal to her, having nothing to do with her relationship with the other jurors or her view of the case. And she was discharged.
I haven't read Connor in a while, but
yeah.
Does Connor say that that's take into account the defendant's acquiescence at all?
I don't recall either, Your Honor. Finally, I would like to.
Can you, just before you leave, Connor, can you tell me what it is that the judge did wrong?
The judge, so when the judge.
Vis-a-vis Connor.
Yes, vis-a-vis Connor. The rule in Connor is you're supposed to ask the juror whether, the court's supposed to ask whether she has a problem personal to her that has nothing to do with her relationship with the other jurors or her view of the case. And this juror said right at the outset, they don't like me because I'm dissenting. Now, of course, she wasn't all that likable.
That inquiry with the juror is fraught, correct?
It's very tricky.
Okay,
it is, Your Honor.
But instead of having that tricky inquiry, the judge had both sides saying, "We want her gone."
Only at the very end. At the very end, both sides we said we want her gone, and that's why I have to admit that the standard review is substantial risk of miscarriage of justice. I would like to make my 33E argument here. I did look for other cases like this, and there aren't any that I could find.
That's not really surprising, is it?
Well, this is quite a heinous crime, Your Honor.
Right.
And it's very, very tragic.
But there are other cases in other states, right, on this sort of killing?
That may be, Your Honor. I don't know if I saw that. But I will say that I would urge this court to consider some of the errors that I think occurred during the trial, consider the state of defendant's mental health, consider his testimony, to consider the fact that there was corroborative proof that this had happened before.
What do you say to the continued use of the doctrine of provocation when there's knowledge of infidelity? We've questioned it in 2 cases. What should we do with that?
Yeah, I'm aware of that, Your Honor. Of course, I'm here arguing under the state of law as it is now and at the time of trial. And at the time of trial.
This gives
and-
us an opportunity to write on that, so I just want your view on
Well,
this.
obviously, what I would say in the interest of my client is that if this court changes the law on that, it can't be retroactive to this case, of course. There would be due process concerns. But, and so I'll just rest on what I have in the brief about that. But I think it's the question, although I respect it, Your Honor, is entirely academic to the result here for my client.
I think what you said in your brief was this is different because there was infidelity plus paternity.
That's right, Your Honor. It's an unusual situation to say the least. He learns two incredibly shocking things at once.
Although, don't they go together?
Of course.
Okay, thank you very much.
Thank you.
Attorney Moriarty.
Good morning. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honors, the claims related to the fetus were never raised below, and even if they had been, where the conviction is supported by the law, the facts, and consonant with justice, the arguments are without merit. With respect to Commonwealth v. Cass, the defendant has set forth no solid rationale for overturning 38 years of precedence, which was most recently upheld in 2000 in Crawford and noted favorably in 2012 in PUG, P-U-G-H.
Is that the majority rule or a minority rule, if you know?
With respect to the states?
Yeah.
I am not sure, Your Honor. I don't know. I did not research that. With respect to the conviction for deliberate premeditated murder of the fetus, it was based on sufficient evidence of intent. The jury could have found that the defendant intended the murder days, weeks, even months leading up to the stabbing of the victim, the pregnant woman, or the defendant could have formed the intent as he was in the apartment just prior to the stabbing. Next, Judge Lowy correctly instructed with respect to the charge of the murder of the fetus in accordance with Crawford, using the reasonable likelihood standard, which he was instructed to explicitly by Crawford. Turning to the issue of whether the defendant was required as a matter of law to be found guilty of only manslaughter based on reasonable provocation, the Commonwealth does urge this court to retire the antiquated theory of reasonable provocation upon sudden revelation of infidelity as suggested in Richards, which was published in 2020, and most recently in Steves, which was published in 2022, just after the Commonwealth filed its brief.
And did you have an opportunity to look at other jurisdictions on that issue?
I have not, Your Honor. I have not. But I would suggest that this court has been intimating that society no longer would find a reason or excuse to justify a killing based on these words alone.
And can I ask you to address your opposing counsel's statement that this involved not only a sudden revelation of infidelity, but also of lack of paternity?
Your Honor, it simply doesn't matter. The standard rule is with respect to provocation is that mere words are not enough. This court for decades has carved out this very small area which said that sudden revelation of spousal infidelity is an exception to that cardinal rule with respect to reasonable provocation. It has had to expand that rule with respect to relationships that are outside of the marital realm. I do not think that the society should expect that words are sufficient provocation. In fact, the Commonwealth objected to the manslaughter instruction being provided with respect to both the victim and her fetus. It was clear that Judge Lowy felt constrained by the case law and provided the manslaughter instruction, which the jury did not accept. Judge Lowy only indicated he only provided the instruction based on the defendant's self-serving statements that he felt that he and the victim were spiritually connected. The Commonwealth's position, as it was at trial, perhaps Judge Lowy's decision was or is correct at the time. However, going forward, the case law should be now that mere words are not enough, period.
Did the prosecutor make a mistake in arguing transferred intent?
Your Honor, I think she could have suggested better words. I think transferred intent to lawyers and judges has a very specific meaning. However, the jury was never instructed about transferred intent. They never heard those words. I think what she was going for was the more colloquial dual intents, or that the defendant could have had two things in his mind as he was stabbing his pregnant girlfriend 15 times. That it's simply incomprehensible to think that the fetus inside the woman he was stabbing was not on his mind, when in fact, even according to the defendant's own statements, the whole argument—
It has to be intent to kill because it's premeditation, correct?
Yes, that the intent, that there is only one intent. When you intend to kill a pregnant woman, there is one intent. It's common sense that the fetus inside her will also die. So as he's intending to kill Galperina, he's also intending to kill the fetus. In fact, there's no claim that he didn't know that she was pregnant. The Commonwealth's not arguing some strict liability standard here. He obviously knew she was pregnant. She was clothed in her underwear. She had a 9-month pregnant stomach. The fight itself was about the baby, was about how they're going to raise the baby, how they're going to raise the baby together or not raise the baby together. So the idea that there's some lack of intent to kill the fetus is simply not borne out by either the defendant's own statements, which were also corroborated by the Commonwealth's evidence. Briefly on the discharge of the juror issue, the defense attorney kind of drove the bus with respect to what he wanted to do with this juror. Judge Lowy was flummoxed. He was concerned. He said in the end that it was one of the most difficult decisions that he'd ever encountered as a judge. The defense attorney asked for the voir dire of the foreperson who brought forward the juror slip. The defense attorney asked for the voir dire of the juror in question. The defense attorney said, at this point, I ask that the juror be dismissed. The Commonwealth, meanwhile, was taking a much more reluctant approach. The prosecutor said she was consulting with the appeals division and didn't really take a position until the very end. And finally, Judge Lowy, once he got the consent of all the parties, he said he would do a colloquy with the defendant. He engaged in a colloquy with the defendant specifically, and the defendant specifically said that he agreed with his attorney's advice and wanted the discharged juror.
There's no ineffective assistance claim related to this, right?
Your Honor, I don't think so. The only thing that Connors requires that arguably Judge Lowy didn't get to is that one line inquiring of the juror that you can only be discharged if it's something unrelated to your position as a deliberating.
I understand the Connor issue is just defense counsel wanting the person off is a little odd.
Potentially, Your Honor, but that's the point, and that's the point that Judge Lowy was trying to make on the record, is that none of us were there. He said on a naked record, it's difficult to explain how disturbed this juror seems, her negative and hostile interactions with the court and the court employees. There was discussion about how she was mentally unstable. So I don't, with all of that said, I don't see how a defense attorney would want a mentally unstable person on the jury.
But in terms of the law that we've sort of come up with on this, did the judge err by saying, if everybody agrees she shouldn't be on the jury, was it actually an error not to go through the figuring out whether she's got issues personal to her?
I think it was, I do not think so, Your Honor, but I don't think so because he couldn't get there. Her responses to him were so non-responsive and hostile that Judge Lowy simply couldn't get to the point where he could have not even intelligent, just a normal conversation with this juror about her issues on the jury without delving into the deliberations itself. He had to tread, obviously, very, very carefully, and I think he did. So I think that this, and there's no indication, this was on the second day of deliberations, there's no indication that the jury was at a deadlock. There's no indication that this was a holdout juror. The only indication is that this juror was damaged, mentally unstable, hostile, and unable to work with anyone in the courthouse. So I don't think,
So I'm just thinking about, for trial judges who have a very difficult person who obviously has issues, but the issues may be both outside and inside the jury room, and everybody agrees she should go. Is there a problem with that, or?
I think if defense counsel consents, then if there's any error raised, it would be a substantial risk or substantial likelihood of a miscarriage of justice. They would have to prove some sort of prejudice, which I think it's, and I also think, Your Honor, that there's significant deference accorded to trial judges in these particular cases. So I think actually the standard is that you have to prove that it was that Judge Lowy in his decision was a palpable error, and I just don't think that on this record that is evident. Unless the court has any further questions.
I did have one question. Why not adopt the federal 703 evidentiary rule on expert testimonies? What's the Commonwealth's position on that?
Your Honor, just with respect to this case, yes, the expert's testimony was very lengthy and long. However, this particular constraint that was arguably put on the expert only lasted for 3 transcript pages. So it wasn't like the expert was forced into this, for hours, into this potentially unnatural testimony. He gave the jurors all the information they needed about the defendant's mental health deficits, and in a very particular way was required to opine on the facts of this case. I don't think that it's unreasonable to require an expert to opine in this way, because arguably the expert is getting into, has information that is beyond what the jury has. So I think there's a very a difficult line that has to be drawn, and that's why the information that the expert relies on is only permitted in on cross. So I think that the way that our rules require experts to testify is most consonant with the Commonwealth's common law rules of evidence.
It's a hearsay dump, right?
Essentially, yes, right. It's a way around the hearsay rule.
Right, but the federal courts do it all the time. Why shouldn't we allow that here? Why have experts testify in what you concede is sort of an abnormal way, albeit only for 3 transcript pages here?
Well, first of all, I think it is within the judge's discretion to allow an expert, and in this case, the judge did allow the expert to testify more naturally. So that I think it's better to allow the trial judge discretion with respect to how to manage the expert's testimony.